staying with us, and even through the hectic vote schedule. I'd like to go back to civil forfeiture, if that's all right, which was the topic we were discussing earlier before I left for the last vote. First of all, I want to get back to the question I asked at the outset. Do you think it's fair, is it fundamentally just, that someone can have their property taken from them by the government without any evidence that they've committed wrongdoing, based solely on a showing by the government, based on a probable cause standard, that their property might have been involved in the commission of a crime, perhaps without their own knowledge, their own consent, their own awareness on any level? Do you think that's fair?
Senator, I think that we have a very robust asset forfeiture program, both criminal and civil. With respect to civil forfeiture, I've looked at the program in general. Again, the department is conducting a review of the forfeiture program. And with respect to civil forfeiture, there are legal safeguards at every step of the process, certainly as instituted or implemented by my office and my understanding by my U.S. Attorney colleagues. So there will be judicial review before there can be attachment or seizure, for example, as well as an opportunity to be heard. And that standard must be met before the seizure warrant can be issued.
I understand. I understand. A lot of Americans don't believe that that's fundamentally fair, and again, that's why in many states there have been laws enacted that restrict the use of civil forfeiture under those circumstances and impose additional requirements, which is why I raised the concern about the process by which the Department of Justice has on occasion in the past used something known as adoption, whereby they will take something that could not be forfeited under state law in state court, and they'll utilize the resources of the U.S. Department of Justice to assist in the forfeiture. The U.S. Department of Justice retains 20% and then yields back 80% to the state or local law enforcement agency. This is troubling, and you appeared to be aware when I asked you about this. You appeared to be aware about an order that Attorney General Holder issued just about a week and a half or 2 weeks ago. I believe it was on January 16th, restricting that. So I assume you're familiar with that order.
There was an order or policy directive from the Attorney General to the field, and as U.S. Attorney, I did receive that, and it essentially ends the adoption program. As you point out, Senator, a number of states now do have a robust asset forfeiture program on their own. When the federal program was being instituted, at least the research shows, many states did not have this program, and so a lot of the local law enforcement agencies that have been using the adoption program initially did not have a venue to effectuate legal seizure of property that had been used in a crime. And the adoption program began several years ago, primarily as a response to that. That has changed. That legal landscape is very different. And that certainly was one of the reasons set forth in our discussions when the policy change was made.
Okay, so this order that the Attorney General issued on January 16th, you referred to it as essentially ending this adoption program. Again, the program by which the federal government can assist state and local law enforcement agencies in circumventing their own state law restrictions on civil forfeiture. But when you read the order, you see that it's subject to several exceptions. One exception applies with respect, I think you referred to this briefly before when you and I spoke a few hours ago. One exception relates to property that directly relates to public safety concerns. Fair enough. Then you turn the next page. You look at the second to last paragraph, which contains some additional carve-outs. This order does not apply to, 1, seizures by state and local authorities working together with federal authorities in a joint task force. 2, seizures by state and local authorities that are the result of joint federal-state investigations or that are coordinated with federal authorities as part of ongoing federal investigations. Or 3, seizures pursuant to federal seizure warrants obtained from federal courts to take custody of assets originally seized under state law. So, as I see it, Ms. Lynch, this order, while purporting to end this adoption program, as you say, is riddled with loopholes. It's riddled with loopholes that effectively swallow the rule, which seems to be a recurring theme today, which is something that concerns me greatly with this department. Now, I understand that this order was issued it has been issued prior to your confirmation, after your nomination, prior to any confirmation vote on your nomination. But I would just ask you to take into account these concerns and to work with me moving forward on making sure that our civil forfeiture programs don't get out of control. But would you agree with me that we really ought to find ways to stop federal law enforcement agencies from helping state governments to circumvent their own state law restrictions on civil forfeiture?
Senator, I believe that the policy change that ended the adoption program certainly ends that as the problem that had been raised. As you pointed out, these were situations where local law enforcement made an initial stop or seizure, so the seizure was not essentially begun by a federal agent or partner, and then the matter was brought to a federal agent for adoption and processing through the asset forfeiture equitable sharing system therein. The other situations to which you refer, where there is either a federal state task force or a joint investigation, really are situations where there's actually a federal case from the outset, and there would not be the issue of having to review the state laws, and they would not be an option in that case because, again, the case would be under federal jurisdiction from the very beginning. So, as you've pointed out, the initial adoption program did raise concerns, and I understand that those have been discussed in the public discussion venue as well as in law enforcement circles as well, about the issue where the state has a robust system of asset forfeiture, but that system is not being used and the federal system is being used instead. The adoption program ends that practice.
It ends it, but subject to some very large loopholes, and so I just ask you to be aware of that, and I'd like to discuss that with you more moving forward.